have breaking news here on KGW Plus involving the deployment of National Guard troops to Portland. Thanks for joining us. Now, just a short time ago, the Ninth Circuit Court of Appeals ruled in favor of the Trump administration in a 2-1 vote. So what does that mean? And where does the state of Oregon and Portland go from here? We have plenty of questions, and joining me to answer some of them is Laura Appleman. She's the Van Winkle Melton Professor of Law at Willamette University. Laura, thanks for being with us. Let's start with this. Was the outcome of this a surprise to you?
Hi, Stephanie. Thanks for having me. No, not at all. I think anyone who watched the hearing on the Ninth Circuit last week, it was pretty clear that Judge Nelson and Judge Bade were going to likely rule for the government and that Judge Graber was going to write a dissent, and that is exactly what happened.
Well, let's talk about what was in this. It was a 93-page, 92-page opinion. You briefly reviewed that for us. What are your takeaways from what the judges had to say?
Sure. Well, first part, most important for the binding law part, is what's called the per curiam opinion. So this is where two judges, again, Judge Nelson and Judge Bade, agreed, and they held. It was a long holding, but they held essentially that subsection 3 of 12406, which allows the president to federalize the National Guard, gives the president a tremendous discretion to do so, and thus the stay put on the president's initial grant of power to do so is dissolved. So the TRO that the district court extended last week below is now no longer in effect. Short, summary of that is that we can now send the Oregon National Guard to Portland.
Yes, so the appeal from the lower court from Judge Immergut has now been overturned, and Trump may now, as you mentioned, send the troops here to Portland as he wishes. Where can the state of Oregon and Portland go from here?
Well, in theory, the state of Oregon and Portland can try to appeal this to the Supreme Court. One of the things that I think is interesting about this opinion, there's sort of the first part, what's called the per curiam, where we have the two judges that agree, but then Judge Nelson actually wrote a concurring opinion. So an opinion where he explains what he believes is the Ninth Circuit reasoning for this. And he says that this should be something that's reviewable not by the courts or by political power. So actually, let me correct myself. I said the Supreme Court. What might happen next is that the Portland and Oregon may call for an en banc Ninth Circuit hearing. So since the Ninth Circuit is so large, that wouldn't be the entire Ninth Circuit. That would be probably 10 of the judges, plus, of course, the 3 original judges. So it's likely the next step.
I want to speak to that, as you mentioned. So Oregon's Attorney General Dan Rayfield did release a statement just in the last hour saying, quote, Oregon joins Judge Graber in urging the full Ninth Circuit to act swiftly en banc to vacate the majority's order before the illegal deployment of troops under false pretenses can occur. And like her, we ask those who are watching this case unfold to retain faith in our judicial system for just a little while longer. He also went on to say members of the Oregon National Guard are our neighbors, family members, and friends. Their safety is important. As a community, we need to come together and help make sure they are sent home as soon as possible. That means keeping Portland peaceful and safe while our fight in the court moves forward. So all of this is really complicated. I mean, it really is. I feel like I've gotten a lot of lessons in law recently. But what exactly would that look like then if you were using the en banc or en banc to vacate the majority? How would that work?
So essentially, so Judge Graber can actually ask for an en banc. She's a senior judge, but she can still ask for a Ninth Circuit holding to be reviewed as long as you're on the panel. And so then the Ninth Circuit needs to decide whether it votes to grant that en banc. Now, again, normally in all other circuits, that's the entire judiciary, but because the Ninth Circuit is so large and has so many judges, they usually limit it to 10. And usually those hearings take place in San Francisco, although, of course, now you can do it on Zoom. And so I assume that the request has already been AG Rayfield and through Judge Graber. And so now, I guess really the next step is we wait to see.
How long typically would that take?
I'm assuming that since all of this is deemed pretty time sensitive, that we will likely have an answer in the next couple of days, but there's no sort of set rule for this.
What does this say about the president's power when it comes to Section 12406 in other states as well?
Right. So in the Ninth Circuit, at least, and of course, the Ninth Circuit involves Oregon, California, Washington, Idaho, Montana, Arizona. This means that the president's power, especially in Section 3, right? So Section 3 is when the president can federalize the National Guard because they're having difficulty enforcing the laws. That basically his power is, if not entirely unreviewable, highly discretionary. And this does seem to conflict a little bit with what the Ninth Circuit, a different Ninth Circuit panel, held in Newsom. And so it's not uncommon for there to be slightly different interpretations of things, both within a circuit and then, of course, outside of the circuit. But this is where, again, Judge Nelson's concurrence really spends a lot of time and actually goes back and talks about 3 tax rebellions, Shays Rebellion, the Whiskey Rebellion, et cetera, where what the predecessor to 12406 was used, and looking to what was the original intent, which Judge Nelson notes that should be the viewpoint as well, saying this is something where the president should not be cabined by the judiciary at all. This is the political process.
Can you remind viewers what Section 12406 is in layman's terms, and kind of what was the crux of the argument that these 2 judges sided with to allow this appeal to happen or stay?
Of course. So 12406 is the statute that allows the president to federalize the National Guard. And so there are 3 sections. Subsections, the one that we care about here is when the president federalizes the National Guard because the area or the people cannot uphold the law. Now, a lot of the actual opinion is very factually based. So they held that the district court committed error in the district court's interpretation of the facts, particularly in the sense of time framing. So that's a fancy word that means how far do we look back when we look at the September 27th, 28th order saying we need to federalize the National Guard. So Portland and Oregon said, well, right before that in September, things were very quiet. In fact, Judge Graber's dissent pointed out there were a 2-week period where virtually nothing was happening. The government and the president are saying, no, actually, if you look back towards June and July, there was a lot of unrest, and we need the National Guard to help. The other issue that they're arguing about, in sort of 2-to-1 fashion, is the Federal Protective Services sent 25% of its force to help support ICE to make sure everything is fairly calm. And so there's an argument, is that regular force or is that federal national force? And so the government is arguing because that takes the Federal Protective Services, those people away from their other work, they need something like the National Guard. Now, let me say, I think if the Oregon National Guard is sent to Portland, we will likely see an uptick in protests. In fact, we've seen an uptick in protests since September 28th, just for reacting. So
I wonder, did the justices or did the judges mention anything about that this may, or was that an argument in the case that this may cause more harm down the road?
No,
It
no,
was not.
this is just purely on the facts that had happened, not looking forward.
So, of course, we saw the Judge Immerget block the Oregon National Guard troops from deploying into Portland, and then we saw President Trump bring in troops from other states, including California. They are still training. They are on standby. How do they play a role here, and what does it mean for the troops from other states now?
Right. So this is why this case is incredibly complicated. So there are actually there were two temporary restraining orders. The first temporary restraining order on which this opinion today directly addresses is the Oregon National Guard, who are in Oregon, but of course not in Portland. The second temporary restraining order is on the California and Texas National Guards, which have also been sent to Oregon. And the Ninth Circuit held today that their opinion deals with both temporary restraining orders or TROs. And so if presumably if Oregon can come, also California and Texas can come. Although I think if Oregon can come here to Portland, I think the need for California and Texas will be moot.
So just to be clear, the ruling today basically stayed both of the temporary restraining orders that we saw weeks ago.
They dissolved them.
They dissolved them. So both of those cases, the troops would be able to come in, whether from Oregon or in another state.
That's right.
Okay. I want to read some of Judge Graber's dissent now that we have here. She said, quote, "Today's decision is not merely absurd. It erodes core constitutional principles, including sovereign states' control over their states' militias and the people's First Amendment rights to assemble and to object to the government's policies and actions. I strenuously dissent." What stood out to you about her dissent and her opinions here?
Well, first, she, in general, her view of the facts really supports the district courts. In the bit that you've just read to us and put on the screen, she is arguing a 10th Amendment argument. So the 10th Amendment, for those of you who don't strangely recall, says that all rights not used by the government are reserved to the states. And so she's arguing that this order of federalizing the National Guard is taking away Oregon's right to decide how to use its own state militia. And of course, this is also, I would say, a primary aspect of this case, but where does the federal government's power end? Where does the state's power begin? Because of course, this is not, as we've seen in the past, where the government of a state or a city has asked the National Guard to come in. This is the government forcing the National Guard in over the protests of both the mayor and the governor. And so I think that's why. And I think it's an interesting fact to note that Judge Graber is a longtime Oregonian, right? She sat on our Court of Appeal. She sat on our state Supreme Court. And so she is tied to the community in a lot of very important ways.
How would that differ from our two other judges, Nelson and Bate?
The two other judges they're more recently appointed in 2019, and neither of them are from Oregon. I don't know off my head, but they're not long-term Oregonians. And so not to say that a judge's opinions on this are totally driven by their backgrounds. I think all of the opinions are deeply steeped in fact and law, but I think my sense is that Judge Graber's strenuous dissent might also stem not just from her reading of the law and the facts, but also that she is an Oregonian who lives in Portland.
I think it's also important to note, right, though, that Judge Karen Immerget also is a Multnomah County judge,
right.
And she was also appointed by Trump. So she ruled against the government and in favor of the state of Oregon for, of course, that temporary restraining order. And so it is interesting to see that playing out differently.
Right. I think there's a lot of airtime of who is appointed to the Ninth Circuit or the District Court by what president. I think when these judges actually begin to serve, it means a lot less.
Do you anticipate that we will see more of these troop deployments now happening around the country now that we have had this ruling or this decision today?
I mean, I think it's possible. Of course, not all other circuits agree with the ninth, at least this Ninth Circuit, but I think other circuits may say, if they feel it's correct, that yes, look, if there is trouble or protest outside of ICE facilities, that there's another circuit that is allowing the sending in of the National Guard over both the governor and the mayor of Portland. So I think it could definitely give support. Now, if we have lots of different circuits disagreeing, this might be something that the Supreme Court could pick up, but that I don't know.
We've been waiting for this ruling from the Ninth Circuit for a week and a half, so it's been a while. Yeah. What does that say to you about maybe what was going on behind the scenes with this?
First of all, I think for those people not sort of used to the pace of appellate courts, this is a really fast opinion. I mean, I know I was checking for this opinion about once an hour, roughly.
Yeah.
But this is quick. Now, again, this is sort of me reading the tea leaves with no personal knowledge. I think it's because not only do we have, a three-judge panel which is divided, but we have, as I said earlier, the per curiam opinion, which is a fancy way of saying two judges agree. And then not only do we have Judge Graber's lengthy dissent, but we have Judge Nelson's concurrence. And so what often happens in writing these opinions is that they are circulated. These three pieces of writing are not sort of written in secret and then sort of brought out. They circulate to each other. And so I'm sure there's been a lot of writing, a lot of rewriting, and I know the judges were all working very hard and very long hours, as most judges on the Ninth Circuit do.
It is interesting that you mentioned this is actually very quick, right? Because like you said, for us, it feels long. We wait every day. Right. It's a big decision for people. I want to ask finally today, what does this say and how does this play a role into the larger lawsuit that we have from the state of Oregon and the government around this issue?
I mean, obviously, this is just a smaller facet of when you can, really focusing on what's the correct use of ordering the federalization of the National Guard. I do think it's interesting that one of the ways that Portland is trying to deal with the ICE facility entirely is zoning. Not only have they filed a zoning complaint against ICE for boarding up their windows, they are now also, and this is, I believe, in the New York Times today, filing a zoning complaint against the ICE building because evidently when ICE, decided to rent the building, it said it wouldn't hold people for longer than 14 days and it may be in violation. So some of this may actually come down to zoning and property law, which I think is not what people are thinking about when they think about protesting ICE and, the federalization of the National Guard.
Yeah, it feels like technicalities, right? Really.
Technical, although I will say that Oregon is famous for having very strict and very unique zoning. It's a very special Oregon thing. So if this is, for some reason, decided on zoning, that would be a very Oregon determination.
Laura Appleman with Willamette University, thanks so much for breaking this all down for us today.
Thanks so much.
We'll have much more on this story throughout the day on KGW Plus and coming up today at KGW News at 4. Thanks for watching. We'll see you then.